Welcome to the Indian Journal of Law and Public Policy Podcast.
Hello, everyone. Welcome to the last episode of this season for the IJLPP Podcast. I'm your host, Pranav, Tanwar, and here we discuss major happenings of the legal and policy field last week. Today, I'm joined by the same counterparts from the journal who were there with me when this podcast began in March, Aakash, Chandran, and Saurabh Pandey, consulting editors at the journal. So, beginning with the suo motu case, which is also known as In Re Problems and Miseries of Migrant Laborers, the three-judge bench of Justice Ashok Bhushan, Justice Sanjay Kishal Kaul, and Justice M.R. Shah has finally taken up the issue of problems related to traveling back of migrants to their home states. A detailed order has been passed today where the court inter alia has given guidelines such as transportation of migrants within 15 days and if demand is there within 24 hours. Cases against migrants has to be dropped and interestingly a very strong order of rehabilitation where the government has to map employment relief for migrants. These directions are in furtherance of already made directions such as free travel of all migrants and availability of food and water. Now, as good as it may sound, the proceedings turned out to be ugly. There were remarks made by the Solicitor General against the opposite parties, which have been criticized in different opinions across platforms. Further, there have been inconsistencies of the government stand in and out of court. The SG point in the court was that the government could not anticipate such large-scale movement, whereas the Home Minister has said that they were prepared well for the migrant problems at the time of the lockdown. So, taking Akash Chandran's view first, Akash, let me take your opinion on the underlying political tone of these entire proceedings. And did you feel that there was lack of transparency on information presented to the court, for instance, on fair distribution? What do you think?
Right, Pranav. I think the whole episode has to be put into perspective first, by the account that it took Supreme Court like weeks and months altogether to take cognizance of the matter. The facts didn't change; the conditions got exacerbated, and this suo motu cognizance, which is now hailed at some corners of the legal industry, but they overlooked the fact that there were repeated petitions, and at the end, it was I think, the letter written by 25 senior advocates that made Supreme Court take notice of this plight. So I'm not sure whether this is humanitarian considerations really what changed for Supreme Court to take account now. But having said that, now what they have done is passed series of orders, which I don't think is going to change significantly any situation for migrants as such on the ground, because most of the migrants have traveled back to their homes. And even if I have to believe that there are a considerable number of migrants who are still on the ground, the lack of coordination between center and state are rendering their movement like really difficult. Even now, these are the private, consolidated movement and networks which are ensuring that migrant workers reach their homes. So you have NALSAR and many law schools like NLS, senior advocates, you know, chipping in, NGOs chipping in, and ensuring that the food and uh, the water is made available to workers. There is no coordination within the railway itself, so you don't see a board clearly, or communication from the central railways informing migrants as to what trains and to where will they go. So these are dependent. These migrants are dependent on the information which is provided on the ground. So every day they have to go and check the board physically every day and figure out whether the trains are supposed to leave or not. And regarding especially the fare prices and like who will bear the cost of these travel is like really problematic, is because when the whole sort of exodus began, uh, we were told that 85% of the fare will be borne by a railway central ministry, and 15% will have to be borne by the state itself. But now, as per the SG's comment and the statement in the code itself, the whole cost has to be borne by state government. So what happened to the previous made assertion and previous made statement before the court that 85% of expense will be borne by them? So this complete, shift of the expense on state governments who are already uh, finding it difficult to meet the requirements as such. Uh, I think it completely overlooks the fact that center has a responsibility. And SG, besides being representative of the government, he's a legal officer of the court. And like many articles have pointed out, and especially senior advocates, that there is a decorum that has to be maintained, and it is expected from the senior most representative of the government, the legal representative of the government. And that was the comments made by him were surprising, distasteful, to least to say, because he compared people, especially senior advocates and the people who bring in the attention to the court as to the plight of migrants and other people as vultures. So these are the terms which doesn't suit the profile and the office that the SG hold. So that very particular notion that there are outsiders or there are the others who are hell bent to create a ruckus and do away with the judicial independence and try to kind of blame government is completely not accepted first, and not called out for second, because these are the people who, because of whom the facts are on the ground, and especially without even undertaking their address and their concerns, like senior advocates who were representing NGOs and civil liberties organizations who were giving out facts and the scenario from the ground, like people like Indra Jaising, were not given that much of a time to report the factual situations, and without which I don't know how Supreme Court is trying to take into account the plight of migrant workers. The only source of information before the court then is the notification or affidavit filed by a state. So the whole purpose of PIL itself is kind of frustrated, and when you don't hear what is happening on the ground and through the people. So this whole proceeding for me is like a sham process. I don't see any positive result coming out of it. I hope if center and state work towards like in unison, and if they can contribute to a better or facilitate, that would be the right word, better movement of migrants, whoever is left now in the cities, I think we'll be saving our institution's grace, if I can say that.
Yeah. So Saurabh, you heard Akash's view, and I think it's something which has been, his opinion resembles to a lot of what senior advocates has written about. And from the senior advocates, and that's so when Akash has pointed out that the situation has got exaggerated now, and the role of NGOs is coming out actually in return, and the government is actually failing on that part. So one of the senior advocates of the Supreme Court has, written an article where he has said that suo motu matters require assistance of amicus or some court-appointed party which can guide court on facts and situation on ground. And similarly, a report was made by Bar and Bench on the opinion of the former judges on suo motu proceedings, which brings out that probably there is need for some out-of-government opinion as well. But this case in its initial major part lagged it in, substantially. Only at a later stage, NHRC has been allowed to intervene. So, what do you think? Does that change the meaning of what suo motu proceedings actually stand for? And as just in the light of what Akash Chandran ended his opinion on.
Thank you, Pranav, for your question. As Chandran very nicely pointed out, what were the issues which came before the court, and what were the problems which were continuously going on around. Coming to your question, Pranav, absence of amicus. First, our listeners need to understand what is the job of amicus curiae. For this, they can also refer to few of the cases which has been taken by the courts in last couple of years. You see the case of appointment of judges in district judiciary. You see the cases of prisoners in the jail. You see the cases of POSCO courts in various districts of our country. In those cases, amicus curiae were made. They presented the real picture of the issue, be it the prison issues. It was just because of the amicus job. Prison committee was formed by the court in the chairmanship of Supreme Court judge. So these were the tasks which amicus curiae strictly used to do, and they used to present the real picture in front of the court that what is happening. Because being in democracy, it's all about accountability. If I am responsible for some work, and if I am only being asked whether you have done this work or not, and there is no one to check whether I have done this work, obviously I'll be putting a real, not a good real picture, but a better picture or good picture in front of the courts that I have done the work. In practically on ground, there may not exist any kind of work. This has happened in the present case. Amicus curiae could have given the real picture of the issue, but same has not happened in the present case, as there was no amicus appointed by the court. Firstly, Aakash Chandran very nicely said that the suo motu cognizance took lot of time. After 25 senior advocates wrote to the court, and everybody from the legal fraternity believes this, that Supreme Court could have jumped in really in the like first week of April, where they could have done or passed real orders in case of depending on the executive. And when you see the March 31 affidavit by our SG, where he said there are no migrants on the roads, that itself was a lie, which for which SG should be at least given some words to him that your affidavit was a blatant lie, because after that we have seen people dying on roads. We have seen n number of events happening to them. We have so many videos circulated by the news agency. Example, you can see that even after the 31st affidavit, there were cases filed by one of the MP from West Bengal. There were cases filed by the advocates based in Delhi, where they said that state government central government need to come in and they need to act. But Supreme Court didn't pass any order. Even our CGI said that it's the job of executive to do things. We cannot dictate them. But in the past also we have seen when executive couldn't do their job, courts have jumped. They have ensured that executive do not violate the right of general people, the citizen of country. We have seen those time of emergency where courts ensured that rights of people are safeguarded by the court itself. But same has not happened in the present case also. Latest order, when you see latest order by the Supreme Court, they have very nicely appreciated the work of NGO, and they have said that NGOs have done a really good job. The people who help the migrant, they have done really good job. But this was the job for which they have been appreciated. This was not the direct job of NGOs or the people who are coming on the road and feeding the migrants. This was the job of our government. This was job of state government. This was job of central government, where they haven't done their job very nicely, and then there was nobody to check them. There was nobody to question them. We have seen this, and we have realized our fundamental rights are to be protected in the extreme time. This was the extreme time where the rights were violated of people. Right to health, right to live, right to food. Every right was violated by the state. It was the duty of the state, where they could have done a lot, but they haven't done because there was no one to question. It was the job of Supreme Court, where they could have questioned, but amicus curiae, not appointing the amicus curiae, was one of the procedural lapses which I personally feel which happened in the case. This also gave opportunity to the state government and also SG to comment on various issues, where they said we have seen high courts passing very nice orders with considering all the factors about the migrants, be it Telangana High Court, be it Gujarat High Court, even be it Allahabad High Court. There have been high courts where they have been passing very good order for the benefit of migrant laborers, migrant workers. Same was not done by Supreme Court. It was late, but yes, at the end it happened. That should be appreciated, and we are really thankful to the Supreme Court that day before yesterday they have passed some orders which are really beneficial for the migrant laborers. Also, this ticket issue, which was coming every day, every week after the trains were started, this issue still is not clear who is going to pay, who is not going to pay, whether it's state government, whether it's central government. This should have been cleared up way back. This could have presented a much more better picture in front of the migrants. This also could have been if amicus was appointed. Our SG said that central government is paying, then it was state government is paying. There was some confusion going around. All these could have been really solved if there was an amicus who could have presented real picture to the court that, see, this is happening. If SG is saying that there are no migrants in the road, if at that very point, if amicus could have presented a report where he could have just justified his point that yes, there are migrants dying on the road, this could have given a real picture. This could have ensured that orders are passed which protect the rights of migrant labor citizen. This didn't happen labs just because of this not appointing amicus curiae.
I think you both have actually raised very good points of that the role of NGOs and citizens cannot be ignored in this entire noble cause. And on the clear picture, I just add one point that if you actually go through the order which was passed by the Supreme Court yesterday, so if you look at the list of advocates in it, so you can clearly see that there were senior advocates who were appearing on behalf of the state government side as well as on behalf of some intervener organizations. Then there was one AOR who was who represented one of the intervener organization, but his junior was representing a state government. So it was a completely messed up, non-neutral procedure, I guess, and we still don't know where migrants will end up and who is hearing them actually. While some voluntary efforts are going on and some good bureaucrats are working relentlessly for them. And something very much related to this issue of corona and migrants, we will move on to our last issue, which is the Delhi government's order on restricting medical facilities of the union territory and all the private hospitals and nursing homes to only bona fide residents. By the time we have recorded this podcast, the LG has already reversed the government's order and a PIL was filed in the High Court challenging the order. The government in its order had listed 7 documents which needed to be shown in order to avail such facilities through central government's medical facilities in the capital region were open to all. The exception to this order were treatment relating to oncology, transplantation, etc. Also, any medical legal victims of road accidents or acid attacks happening within the NCT of Delhi were allowed to go to even state government's hospitals. Now, the procedure behind this move was a feedback taken by the government from around 2 lakh people, and overwhelmingly by 90%, they said that Delhi government hospitals should be reserved for people of Delhi only, while the center's hospitals should be open to everybody. After that, the CM consulted a 5-member committee of doctors to look at the same question, which concluded that if Delhi's healthcare infrastructure is open for outsiders, then all the beds will be filled within 3 days. Now, there is already a judgment by the Delhi High Court in Social Jurist, a civil rights group versus government of NCT of Delhi, which says that such classification of residents and non-residents for medical treatment is unconstitutional. So taking Akash's view first, Akash, what do you think are the prima facie issues with such an order that you see can pose challenges to any such order again in future?
Right, Pranav. So I think, like you mentioned, we already have a judgment in place from the Delhi High Court itself, which kind of uh, prohibits this sort of classification between residents and non-residents. And I would like to leave it the legal part there. Perhaps I'll come back to it later. But I think it raises 2 3 other larger issues. The first is very fact that you mentioned that the the justification for such a decision was that it was the mandate of the people. I don't know like how many of us did actually send out those or filled out those forms, and I don't know how many responses were taken and how many actually asked or reflected that view. While I agree that in a democracy and a public democracy, the voice of the people has to be heard. But for government to take the argument that this is what the population of my state has asked me to do, therefore I'll be doing that, and that is a dangerous path that we'll be treading, because the legality doesn't shift on the basis of public opinion. The legality of the act will still be judged on the basis of the statute and the law. And here, I don't know, first of all, what law uh, was put in place to make this order uh, sort of healthcare sort of an order in place. Because if that's again the epidemic act that we have in place, I think the legality of that very act and the NDMA itself is problematic, because like we mentioned first or second podcast, that the legal framework under which all these exceptional measures are being taken remains NDMA and the epidemic act, which it dates back to colonization. So the very idea that you will use these broad worded legislation to do away with all the checks and balances that you have in the, under constitution itself. What about the classification under 14, or article 21, right to health as a fundamental right? So these are the larger questions, how you try to portray a public opinion, uh, sort of kind of a populist leader who's trying to take recourse under the public emotions and public voice, and trying to project his own voice through that. So I'm uncomfortable with this very idea of speaking on behalf of people, and facilitating your illegal acts through taking facilitating an illegal act through this legal means. Uh, I'm glad that it is challenged now, but I don't know what will happen to that petition, because already LG has overturned it. So we'll not have a judgment on that per se, if I'm not wrong. However, the second part of it, this is a cabinet decision. It's an administrative measure again that you have taken. So, the range of admin orders that has been passed in last few months, their legality again has not been questioned. Because like we said, even in the migrants issue, the Supreme Court or the constitutional courts have been reluctant to push forward and try to exercise the jurisdiction in this matter. You have few exceptions coming out from high courts. So I hope the Delhi High Court, if there's again an attempt to sort of make this classification and uh, and take away the right of health from large population of Delhi, which is popularly known as city of migrants. So I don't know how many people will be excluded, and this exclusionary health policy in the time of pandemic is to do what? So this again raises a question of larger philosophical question as to whom you want to save, and whom you want to let whom you want to allow them to die. So it's the chief minister or his cabinet is sort of have usurped this position, who will be deciding the fate of population when already health care facilities are in shambles. So now you want to take that call as to who will live and who will die. So I think these are not legal, but these are some underlying questions that are which sits uncomfortable with me. So I think perhaps Saurabh can pitch in on the legality as such.
Sort of, you heard Akash's view, and he very precisely shot down the populist or the political justification behind the move, and has very ended on a note where he has actually questioned even the legal motive behind such move. So we know that public health is a state subject, and there are reasonable restrictions on right to health as well. So do you see such counters or such justifications behind such move can help this order sustain, and does not and like a further move on to what Akash has said on the populist stand, and I counter him with this question to you: that does not states have a say on their resources if in such a circumstance where they may have a lack of it?
Pranav, I would like to add 2-3 points to Akash's view. See, he very nicely pointed out that if people are asked for suggestion and they suggest that Delhi government hospital should be reserved for Delhi people only, tomorrow there can be a situation where they are asked whether this particular minority should be allowed to live in this country or not. And if by majority they say that shouldn't be allowed, then state can justify that by saying that they should be thrown out of the state. This is direct killing of cooperative federalism, which we have seen earlier by the central government. Central government in last couple of years, 4-5 years, you have seen they don't give that much importance to the funds, to the views of state governments. But the step by Delhi government was direct killing of the constitutional principles. Pranav, if Article 19 provides me the right to move in this country, then I also have the right to take services of the state government. Very nicely, it was pointed out before the election of Delhi, in the Delhi election, when everybody was pointing to the policy of freebies of the state government, then they very nicely pointed out that it's not about the income tax. It's about the taxes which everybody pays, whether you buy a Parle-G, whether you buy a pack of cigarette, or you buy a carrot of beer. You pay tax on everything. So it's not all about income tax only. So Saurabh Pandey, who lives in this state for last 6 years and will be living for the next 4 or 5 years. And if I don't have resident card of this country, and if tomorrow, God forbid, if I'm not well, will I be going to Allahabad or will I be going to Noida for getting myself checked? Or will I be only opting for central government hospital? This was a order which couldn't have just like standed in front of the court also, but this was a vague order which was like personally feel that was killing principles of constitution directly. Now coming to the question, reasonable restrictions. Pranav, we have recently seen Madhya Pradesh government took all the maximum private hospitals in their charge. We have seen Punjab government doing the same. This could have been done by the state government of Delhi also. They could have done this by just telling them that we'll be taking your 50, 70 or 80% of seats. Yesterday and today also there was a press conference by CM of Delhi. He pointed out where till 31st July there will be 5.5 lakh cases in Delhi state. So they need to be ready. The reason why we were locked down in our rooms, the only reason given by the states were that we are preparing the infrastructure. We'll be preparing infrastructure for the upcoming days where there will be so many cases. See, pandemic is nothing but failing of a health system. When the health system cannot control the number of patients, that's indirectly a pandemic. Now, coming to this question, they could have also asked for funds from central government. So, in any case, states have done good job. They have done very nicely, ensured that all the patients are treated well. They have passed good orders also. We are not just criticizing them that they are going against the citizen, they are going against everything. It's just that they're also doing good job providing food to an extent, not to everyone, but as much people possible. And also today, when you see an affidavit by the SDM Model Town, he very nicely pointed out that we have been providing these much of packets to the laborers in Azadpur Mandi. Coming to the legal issue, Pranav. First, we have the case of Parmanand Katara versus Union of India, where under Article 21, Supreme Court very nicely laid down that right to health is fundamental right of any citizen, and it's the duty of the doctors and hospital to treat anyone who comes to the door of hospital. The same happened when you see the facts of the cases. Person got himself injured in the accident. He was not treated. Similarly, from last 2-3 days, I was seeing my Twitter feed where I saw that people are not given the proper care is not given at the door of hospital. They are being returned to go to any hospital. We have seen pregnant ladies dying. This was not the job of the hospital. They should have acted in a much more better way. You see the case of Paschim Bengal Mazdoor Samiti versus State of West Bengal in the year 1995, where the same orders with much better guidelines were passed by the Supreme Court. Then you have the case of State of Punjab versus Mohinder Chawla, where Supreme Court directly and strictly pointed out that it's the constitutional obligation of the government to provide health services to the patients, and reasonable restriction should come with due procedure of law. We have seen that in 1975 case of Menka Gandhi, where the due procedure law was interpreted in a way where the procedure has to be followed. That procedure cannot violate your right. And latest case in 2019, Ashwini Kumar versus Union of India, where it was very nicely pointed that right should be made available to citizens, and that has to be considered that it's the right of a citizen to get treated. Whether that's private hospital, that's government hospital, that's another debate. But it's the right of a citizen to be treated. It's also the duty of state government to ensure that private hospitals do not shut their doors for the poor migrants, poor people. Yesterday I was reading this article where a hospital has laid down a brochure for the charges. Is this joke going around in the state that hospitals are laying down the charges like a brochure of a package? Is the hospital deal going around? We are in the middle of pandemic and we cannot tolerate such kind of things where hospital lay down the package of 3 days that it will cost 3 lakh rupees for 3 days. It's not a hospital tour or somebody planning his honeymoon. We are in the middle of pandemic and everybody has to act responsibly, and also both reasonable restrictions has to be kept in mind, but rights cannot be violated of citizen, then state has to put reasonable restriction, but due procedure of law has to be followed by the state. Otherwise, things will turn more ugly, and that will also create issue for both state as well as citizens.
I think Saurabh, you have raised a very interesting point of the aspect of the technical term of citizen aspect of fundamental rights, and terms like residents has no bona fide meanings when it comes to fundamental rights. So if someone is a resident or a non-resident, till they are citizens, they have the right whichever has been given by the constitution. And thankfully, though, the order didn't take place, and politically I think the entire process of passing this order and installing the order has served the political purpose of both state and central government eventually. Aakash, has raised this point, and you, with the instances and legally, have spoken out that how government cannot shed off their responsibility with such move, and they have to ensure it under DPSP or fundamental rights read together and different Supreme Court judgments. So I hope governments realize this fact. They cannot shed off their responsibility with such moves, especially in the time of pandemic when it requires them to move out with much more strong perceptions.
Thank you for listening to the podcast. Do not forget to check our website for more updates and legal articles. You can follow us on Twitter, Facebook, and LinkedIn. See you next time.